We've always thought that one of the most important values in our justice system is the right for all the participants to be with one another in a courtroom, to judge the truthfulness of testimony, read body language, and so on. But for the past year, Ontario's court system has rarely been able to do that. Like so many of our other realities, justice has moved online. How's it working out? Well, let's ask the three senior-most judicial officials in our province today. In the provincial capital at Osgoode Hall, Mr. Justice George Strathy, Chief Justice for the Ontario Court of Appeal, and Mr. Justice Geoffrey Morawetz, Chief Justice for the Ontario Superior Court of Justice. And in the nation's capital, Madam Justice Lise Maisonneuve, Chief Justice for the Ontario Court of Justice. And to the best of our knowledge, this is the first time that Ontario's three Chief Justices have been on television together for an interview. So we're delighted to welcome all three of you to TVO tonight. It's great to have you here. Mr. Justice Strathy, get us started here. I would like to take you back to basically a year ago right now. COVID-19 hits. The province of Ontario goes into a state of emergency. We have a whole host of new protocols in place. What was job one for you when it came to the continuation of the administration of justice?
Steve, I hope I can call you Steve. Thank you so much for having us on your program. As you say, it's probably a first, and it's a great opportunity for us to share some thoughts with you and your viewers. Really, job one was three jobs rolled into one. The first job was health and safety, to ensure that the courts were a safe place for the people who need our services, for the members of the public who appear before the courts, for witnesses, for jurors, and of course for all the staff who work in the court, and particularly those who deal with the public on a frontline basis. The second part of job one was to keep the courts open. The courts were declared to be a public service, or public essential service at the beginning of the pandemic, and we considered our part of job one was to keep that service available. And the third part of job one was to observe the open courts principle, the principle that says that justice must be done publicly and visibly. And if I just look back to what's happened since COVID broke almost a year ago on the province and the country, I would say that from the get-go, we recognized that we would have to be guided by the advice of public health professionals in deciding how we could operate and what conditions we could operate under. We worked together in that regard. We got some top-notch advice from public health officials and from provincial administrators. We were able to keep the courts open, and we have been able to keep the courts open. They've never closed. Not one of our three courts has closed during COVID. We did it gradually. We started dealing with what was urgent and essential for people accused of crimes, dealing with bail, protecting families, and making the courts open for civil disputes. And we've also, thankfully, been able to adopt new technology so that we could actually conduct hearings remotely. And just as you're doing with your show, we've been able to conduct hearings to sometimes in person, but where conditions required it, remotely. And also through the media we've used, we've been able to keep the courts open, whether by audio in some cases or by video. We've made the courts accessible to the public at large. Even 2 weeks ago, we had a case in our court where we had more than 500 viewers watching the case. And as you probably saw last week, Chief Justice Morawetz's court dealt with an important public matter, a sentencing matter in which hundreds and hundreds of viewers watched. So overall, I think that was job one, and we're fairly comfortable with how we've dealt with it.
All right, let me pick up the story with Mr. Justice Morawetz. I know I've talked to people in the post-secondary world who have said that they managed to do essentially in a few weekends what it otherwise would have taken 10 years to do, namely move thousands of courses from the classroom to online. In your case, what did you discover about either how quickly or how difficult it was to pivot to include online in the way you do your work?
Well, thanks, Steve. It was a challenge. We'll put it that way. This is a profession, a legal profession that is steeped in tradition. And we're talking a process where the courts were operating paper-based. And that has been the way in which it's been done for hundreds of years. Bankers' boxes would arrive daily for each judge. You'd lug the work home. You'd do it sometimes at home, sometimes at the office, but all of it was in paper, and all of a sudden you did not have that available to you. We had tremendous cooperation from the entire legal community, and I'll start with our judges. You know, in our court, there's 335 across the province. You know, to a person, they were all saying, what can I do to help? Bar associations, local bar associations, and specifically, I'll give a shout out to the Ontario Bar Association and the Advocate Society for immediate assistance that they provided. The Ministry of the Attorney General, again, came to the realization that we had to do something instantly. So we started with rudimentary email to exchange files, and the bar was great in providing great assistance there. Then we gradually morphed into the Zoom for a Zoom platform for video hearings. We were doing most of them by teleconference. But the result has been, since then, we've now adopted Case Lines as a document sharing platform so that we now can get the documents to judges, to parties, and seamlessly right through to a hearing. And that is in process, but it's going to be finalized by another couple months right across the province. So we have been able, and I'm very happy to say and proud to say that we're closing in on 100,000 virtual hearings in our court since the pandemic started. It took a pandemic to jumpstart it because we've been asking for this technology for years. But now it has been delivered. We're not all the way there. We still have a long way to go. But we've survived and flourished and been able, as Chief Strathy said, keep the doors open and keep justice moving.
Well, that leads nicely to my next question for Madam Justice Maisonneuve, which is, and don't take this the wrong way, but our generation tend to be digital immigrants, I've heard the expression, as opposed to digital natives, which our kids and grandkids may be. So some of this stuff doesn't necessarily come as easily to us as it does to younger people. How much of an adjustment was it for you and your colleagues to do your work under these new circumstances?
So, Steve, you've hit the nail on the head. It was an incredible adjustment to move to what I would call a largely virtual environment, basically overnight, as described by my two colleagues, was enormous. And for the judicial officers, in the Ontario Court of Justice, we have 750 judicial officers. It varied. Some were much more comfortable with technologies than others, and we had to answer those needs and support them to move to a virtual world. But in all three courts, I think everybody stepped up and learned what they had to learn to be, as Chief Justice Morawetz said, just make it happen for us to continue to serving the public. And of course, you have to understand, Steve, that the technology, as mentioned by my colleagues, was not available everywhere. To move to a virtual platform in a large urban center is much easier than in a satellite court in Northern Ontario, for example, where the technology is just not available as available as elsewhere. And I think you need to understand the scale of the operation of the three courts. In the Ontario Court of Justice, we preside in more than 200 locations in 7 judicial regions. In the Superior Court of Justice, they sit in 52 locations across 8 judicial regions. And of course, we have the Court of Appeal. In a year, on average, we receive approximately 240,000 new cases, and that's just criminal cases, and approximately 14,000 family matters per year. And of course, it does not include the Provincial Offences Act, which is close to 1 million at times. And then, of course, you've got the Superior Court. Both courts, we deal both with criminal and family, but the Superior Court also deals with civil matters. And then you have the Court of Appeal, who approximately receives 1,200 appeals per year. So you can imagine how wide and how vast it is. And then, as I mentioned, different communities have different availability to them with the technology. So that was quite difficult. But we did it, and we managed to do it.
And how well is it working in your judgment?
It is working very well. Do we have work to do still? Of course we do. Every day, every week, we have a challenge to deal with. For example, security. When you're running a virtual court, we have to deal with those issues. And I think once the pandemic hopefully finishes, we'll be able to sit down and see what stays and what doesn't stay and move forward. But the last point I'd like to make, Steve, is that it's been difficult for everyone, not just the judiciary, as mentioned by my colleagues, for all stakeholders and for the public to see, where do I go? How do I call in? Who's going to hear my case? How do I file the documents? So if it wasn't for the collaboration of everyone, as mentioned by Chief Justice Morawetz, especially the bar, the Attorney General's office, the Solicitor General's office, because we deal with many people in custody, this could not have been done. So the adjustment was huge, but the team effort was remarkable to make it happen, and everyone stepped up.
As I suggested in the intro, going to Zoom does raise a whole host of new and ethical questions. And Chief Justice Strathy, let me put this quote to you. I was just chatting with I think a well-respected defense attorney the other day, who said, and here's the quote: "It's appropriate where the issues permit this, but there are some cases where credibility is an issue, where you want to see the witness in person. The key is to make Zoom an option, but not mandatory, and up to the defense." What's your view on that position?
I guess my view would be that, we have learned a lot from the use of digital technology, including the use of Zoom. And we found that it has its value and obviously its limitations. It's not necessarily the right thing in every case. But just to pick an example, it's been tremendously effective in allowing people who would not otherwise be able to readily access the courts to have access to the court. For example, would somebody really want to come to downtown Toronto for a hearing in the Court of Appeal that might last for 15 minutes if they're coming from Thunder Bay? Or would somebody who has challenges in getting to the court for a short hearing want to come to court? Or should routine procedural matters be dealt with more effectively over Zoom or in person? I take the point that the lawyer you spoke to made, that in some cases it is important to be in court. I don't think anybody would relish the idea, or any judge would relish the idea of convicting someone of a serious criminal offense over Zoom or over the telephone. I think there are certainly cases where the impact of being in court makes a big difference. There's a sort of cathartic value to parties being in court and seeing and hearing and being in the presence of the opposing party, particularly, for example, in family matters where the judge in person can have a real impact on the emotional way in which the parties receive the message. And the jury's out a little bit as to whether the only way to assess credibility in person is across a room. We all know, I think the judges know, that credibility findings don't just depend upon how the person looks or behaves, but the inherent logic of what they're saying. So we're thinking about it. We'll learn from this experience. I'm sure that we will expand the use of technology in the right way, but there's a lot to still be thought through.
And as a quick follow-up here, if it is a Zoom trial, does it matter where the judge is, as in here in the province of Ontario or elsewhere?
Well, as you well know, Steve, this is a hot issue. We read the newspapers, we hear what's going on. I might just say that, just to return to what I said at the beginning of your program, we've always been guided by public health advice. And the public health advice we've given to our judges we've done this deliberately and in concert, the three of us, is, pay attention to what the public health officials are saying, and don't engage in unnecessary travel outside the province. That's been our uniform message. Now, to return to your question, it's really, frankly, one that I can't answer. These are most unusual circumstances during the pandemic. We're confronting circumstances that we've never dealt with before. We're dealing with technology in a way that we've never dealt with it before. And we may ultimately, and I say we, my court as the appeal court in this province, may ultimately have to decide the issue of whether a hearing held from outside the province is legally effective. And because of that, I wouldn't feel comfortable answering it, quite apart from the fact that I don't know the answer, because the law is a work in progress in this area.
Understood. Chief Justice Morawetz, let's get a better understanding of how much work still happens inside a courtroom versus how much happens on Zoom. How much in-person trial work have you actually been able to do over the past year?
Well, Steve, it certainly depends on the area of responsibility that you're working in. Certain aspects of criminal matters and family matters are much better off in a courtroom and should be in a courtroom. I think a lot of the time that has been spent in the past year has been retrofitting all the courtrooms around the province so that they can accommodate with the safety protocols in place in court, in-person hearings. I think we would all like to get back to, an increased amount of in-person hearings, but we have to be careful. This profession, judges in particular, we're in a position to compel people to attend. And if you're going to compel an individual to leave their residence and travel to a courtroom, you better be very satisfied that that courtroom is safe. And we work very closely with the ministry and with the appropriate health advice to achieve that. So that's where we're trying to get to. As far as the subject matter of matters in court, advocacy is always going to have a place. And I try to draw a line at this stage that if a part of a proceeding is non-substantive, and it could be scheduling matters or consent or unopposed matters, they're far better off being done virtually. And we will continue to do them virtually. It serves everybody much better. Why would you take counsel or an individual 2 hours to travel to a courtroom for a 2-minute unopposed hearing? Just makes no sense. So that's going to continue, certainly in a virtual setting. The other end of things is that if you do have, a trial proceeding or a very complex application that's being heard with many, many documents, that matter where advocacy is at a premium, you're dealing with a substantive matter to be resolved through the adjudication, through the court system, much better off going to be doing it in person. We're then going to have hybrid matters where you're going to have some witnesses or parties from out of town, and you can do that in combination, some in a court, some by virtual. We're still sorting it out, and we have to get a lot of input and advice from all the other stakeholders, and I alluded earlier the cooperation that we're getting from the bar, but we also have to take into account the vulnerable parts of society, those who have difficulties, whether they're self-represented, some other aspect that is going to cause them concerns. We have to listen to that group to ensure that they too are feeling that they get a fair hearing. And at the end of the day, isn't that the objective? We have to be satisfied that those who are involved in the court process feel that they have been heard. They may not agree with the outcome, but they must feel that they've been heard and that they've had a fair hearing in all aspects.
Indeed. Well, Chief Justice Maisonneuve, that does raise the issue of how high a priority it is for you, notwithstanding everything Chief Morawetz just said, to get everybody, as much as possible, back into an actual courtroom.
So the first priority, Steve, of course you can understand, is the health and safety of everyone. And that will take time, and we will have to follow public health's advice to determine will it be completely safe to go back to operations we used to do before COVID. But having said that, I echo the comments of my colleague that it's going to be different even after the pandemic. I think we've learned a great deal from this, and it has forced us to look at other alternatives where I believe it has actually increased access to justice. Having said that, we also have to be careful that a virtual world is not accessible to everyone. Not everybody has access to the internet or a computer or the proper equipment to be able to reach the courts through the virtual world. So we have to be very careful that the most vulnerable of our society are still served. And so I think what you'll see is basically, as mentioned by Chief Justice Morawetz, almost three types of hearing depending on the nature of the case. Fully virtual, fully in person, or more of a hybrid model. And that's what we need to move to next, and to determine what's here to stay and what's here not to stay.
I'm often accused of bringing Bill Davis, the former Ontario Premier, into too many discussions that I do, sitting here in a television station which he created 50 years ago, in a studio named after him, the William G. Davis Studio. And our director, Sheldon Osmond, will now bring up a series of photos from the A. Grenville Davis and William G. Davis Courthouse, which is in Brampton, Ontario, named after the former Premier and his father, who was a Crown Attorney for 30-plus years in what was then, I guess, Peel County. And we can see, and maybe perhaps Chief Maisonneuve, you can take us through some of this. We are seeing, Sheldon, let's see the next shot then, some pretty stark evidence of the fact that the courts are going to look fairly different going forward. Everybody feel comfortable with these changes?
So, Steve, of course, it had to be done in order for us to be able to continue our in-person work and for the courts not to close. And thank God it was done, because otherwise I don't think we could have continued. And you see the amount of work that's been put in there. And that's just one courtroom out of how many in Ontario, many, many courtrooms, as I mentioned earlier. So the Recovery Secretariat from the Attorney General's office worked very hard at getting this done very, very quickly. Do we feel comfortable with it? It's causing issues at times, the sound, the vision lines and whatnot. And hopefully those will be able to come down once we are absolutely certain that COVID is gone. But it was completely necessary. And if the work hadn't been done, the courts could not have continued their operations. So that was a good example of all the work that's gone in to keep the courts open and not having to close them due to the health issue that we were dealing with.
Chief Justice Strathy, have you had to do that down at Osgoode Hall?
Well, we, as you know, we're an appellate court. So we don't have some of the challenges that the trial courts have in terms of witnesses. We don't have witnesses in our court. That's made it easier for us to do remote hearings. But we have several of our courtrooms, or two of our courtrooms are now set up with similar plexiglass barriers and all the other accoutrements to make it safe for in-person appeals. And we actually did some in-person appeals last November using the kind of courtroom that you've just seen. Unfortunately, when the restrictions were increased, we decided to go back to entirely virtual. We will certainly, going forward, if the need arises, be able to do first hybrid appeals with some appeals being conducted remotely, some in person, and we'll see how things go. So we're ready for it. I can tell you nobody thinks it's much fun, but it's necessary, and we'll do it as long as we have to do it.
Chief Justice Morawetz, I know that in our attempts to do this program, it is frequently the case, and thankfully not yet, knock on wood if I had some around here, where the screen freezes or guests get dropped or the lips are moving but the sound is not in sync with all of that. Does all of that happen in your world too? And how annoying does that become, if it does, to try to administer justice in the province?
Well, Steve, it happens. And it's going to continue to happen, although I believe it's better than it was. You just have to accept the fact that the speed with which you can conduct matters is slower in a virtual world than it is in live and in person. You have no option but to sort of wait until such time as the screen unfreezes and that the audio is picked up and is being heard by all parties. The failure to do so would result in a lot more work for Chief Justice Strathy and the Court of Appeal. We have to make sure that we have a proper record, that we deliver justice in an appropriate manner. And to do that, you have to be able to see and hear what's going on. So it slows it down. And you just have to cope the same way that you cope with, I'm sure, some of the guests that you've had on in your program in the past year. But we do the best we can.
Amen to that. Now, what can you imagine, Chief Justice Morawetz, what can you imagine of the new virtual world in which you're working becoming a permanent part of your world, even after COVID-19 is over and done with?
Well, prior to COVID, we had spent years advocating for greater technology and more up-to-date technology in the court. Regrettably, it took a pandemic to achieve it, and we're not all the way there yet, but we are not going back. I think you've heard during this program some of the areas that we think are very, very well suited to be conducted virtually, and we'll continue to do that. Training all the way through the legal process of the legal system still has a long way to go. As judges, the way in which we conduct business has been turned on its ear, but we're now able to, a great example is that we are able from any part of the province to be able to access a file. There are many cases where a little bit of, case management from a judge from time to time can be very helpful in moving the process along. And if we can, use that ability and have a judge wherever they are, whether it's Thunder Bay, Ottawa, North Bay, Hamilton, be able to connect with the litigants on a file, we can move things along. And isn't that one of the objectives that we've got, which is to have access to justice and the resolution of files in a much speedier manner than we have in the past? Yes, there are going to be issues, and there's a lot of concern, I'm sure, in the bar. But we still have to respect, as I said earlier, that advocacy does have its role, and we're going to ensure that matters of substance are still conducted in the courtroom, but taking advantage of all the technology that we now have.
Madam Justice Maisonneuve, I guess I'll give you the last word on this, because if there's one thing I've heard about the court system from so many people, it's that you can drown in the paperwork that has been required in the past. Can you imagine going forward that whatever new virtual online world you're into, it's going to replace some of that needless paperwork going forward?
That's my dream, Steve. So as a result of the pandemic, what's happened is that we had started a process some years ago where we were going to become paperless, and that was called an intake project, which is done basically virtually. And as a result of the pandemic, it's now been rolled out across the province and about to be rolled out completely across the province. And that is the beginning to a paperless world. And once that starts, Steve, it opens the door to many of our front end part of the judicial system, our remand courts, our judicial pretrials and whatnot, to be able to be done virtually and having access to the file, as Chief Justice Morawetz just mentioned, all across Ontario. So it's coming, it's here, and it's something that we've been asking for quite a while, and it's finally here. So I see it happening. Not sure how long it's going to take. There'll be bumps in the road, but I do see it that one day we will be paperless in the Ontario Court of Justice.
I guess, does protocol require me to give the last word to Chief Justice Strathy? Is this how this works here?
Yes.
I'm seeing two others nod. So, okay, George Strathy, you get the last word.
Thank you. Well, I just wanted to pick up on what my colleagues said. One of the things that's happened as a result of all this is that we have surmounted a learning curve in the courts. Judges have been required of necessity to learn new skills. And one example is that dealing without paper, dealing with digital documents, digital exhibits, we have in the space of a year, essentially in our court, and I know in the other courts as well, relying virtually on digital materials. That learning curve has required judges to learn new skills. Some judges who never used a computer are using them on a daily basis. They've applied their diligence and their experience to picking up this new methodology. And I completely agree with my colleagues. We're not going to look back. We've got some huge opportunities as a result of all this, and there really is a silver lining to the COVID cloud.
Well, this was so enjoyable. Should we do it again next week?
You'll have to We'll have to set a special court date for you, but sure.
I can't thank enough Ontario's 3 Chief Justices, George Strathy, Geoffrey Morawetz, and Lise Maisonneuve, for joining us on TVO tonight for, what potentially is a new weekly show here on TVO, because this went so well. Thank you all very much, and of course, stay safe out there. As my dad likes to say, stay positive, but test negative.
Thank you, Steve.
You too.